Thank you again for being here. It's my pleasure to host everybody who's been able to join and to participate in this first workshop of 2025. So thank you so much for being here. I do think you and hope you'll find it valuable. The landlord-tenant law is very simple. Minimize this real quick here because this is interrupting my. Maybe I can go off to the side. There you go. Okay. So hopefully everybody can still see that. If you have comments or anything that you need to put in the chat, we'll do our best to circle back. I'll do the presentation first and then open it up to questions and answers after that, as there's a good chance that what I have in my slides might be something you're thinking about and wanting an answer on. So I'll get those done first and then open it up to questions and answers. In Michigan, landlord-tenant law is rather simple. It can seem complex because of the hierarchy between the federal, state, and local ordinances that govern transactions as it relates to landlord-tenant relationships. So the rights and obligations of a property owner and tenants are governed by federal law, state law, and local law. We have, for example, the Fair Housing Act, the Housing and Urban Development, HUD, Michigan State Housing Development Authority, that's MISHDA, those are those rules. Michigan common law and statutory authority, such as the Truth in Renting Act, or TIRA, as you might know. Local housing ordinances at a local level, like the city of Grand Rapids or others. Zoning ordinances as it relates to them as well, and property maintenance codes, which can also vary by city. Real property is subject to property law. A lease agreement is a contract. Therefore, landlord-tenant law is both property law and contract law. And that's very important as we proceed on cases. So for example, if you have somebody who came into your home without a lease agreement, they've established residency, they're paying rent, there is still an active tenancy there, and you can't evict them without following the necessary procedures. It's just simply what we call an at-will tenancy, for example. Michigan Court Rule 4.201 is where our processes for evictions and other cases like non-payment and termination reside. And so following the processes outlined in Michigan Court Rule 4.201 speaks specifically to the court processes for performing and completing an eviction from the time of filing until judgment and even order eviction if necessary. And again, landlord-tenant laws, rules, and ordinances come from various sources. The Revised Judicature Act of 1961, or Act 236 of 1961, is codified in MCL 600, Section 5714. It was last amended briefly in 2014. So there hasn't been an amendment again in about 11 years. And I say that, but there are some amendments coming, and I will get that to the end of my presentation today. A little bit of a foreshadowing. We did have a Senate bill in Michigan 205, 206, and 207 that was just signed by Governor Whitmer on December 31st. And those changes specifically will take effect April 2nd of 2025. So we're getting ahead of what's coming. But the Revised Judicature Act, as it relates to non-payment or termination cases, outlines the statutory authority for a landlord to proceed with an eviction. The legislative intent behind this statute is time is of the essence, that there is a real need to quickly determine whether it is a non-performing tenancy or a performing tenancy, and that if an eviction case needs to get started in the interest of protecting the homeowner, the landowner, that time is of the essence, and the process need to be followed in a way that speedily resolves the matter. Demand for possessions for non-payment, those are the 7-day notice you may be familiar with. They are the most common form of LT cases, is a demand for possession for non-payment. In most cases, it's a 7-day demand for possession for non-payment in Michigan. I say most cases because if there is a federal HAP contract or other government assistance, there is an unexpired HUD order that is still in effect following the expiration of the CARES Act, which has been interpreted more and more and more in local courts here in West Michigan, requiring that if you're accepting a Section 8 Section 8 housing subsidy, then you will actually be required to provide a 30-day notice for non-payment before you can move forward to non-payment. If you don't do that notice, it's a jurisdictional issue, and it can actually result in your case being dismissed. Now, there's not any binding case law as we've come across it yet. However, here in West Michigan, particularly in Grand Rapids, there is, in fact, persuasive authority in case law that's coming out of that court where they have ruled against a landlord, indicating that a 30-day notice for non-payment is required. Termination of tenancies, this is where it's not about the money. Typically, it's about recovering possession for a behavior reason or for some other reason, like a material violation of the lease. For example, you can give a 24-hour notice for termination of tenancy for unlawful drug activity. That would be a provision of the lease that forbids possessing, controlling, or distributing any sort of unlawful drug. And as a result, you can actually issue a 24-hour notice. You don't have to wait 7 days. The other thing about that particular section is that it can come with a judgment and an order of eviction that can enter simultaneously without having to wait your traditional 10-day statutory time period. Terminations for breach of lease, typically what we call early terminations. Those are usually a 30-day notice. Terminations following lease expiration, those are typically also a 30-day notice. Termination for damage or health to the property. So we're talking about a substantial and continuing hazard that's ongoing in the property that was recently discovered, typically within 90 days. And if you've discovered it recently, then you could issue a 7-day notice for non-payment. The trick or issue there is in landlord-tenant law, you almost have to ask, what is your relief that you are seeking at the end of the case? Are you looking to have the damage or health hazard fixed, or are you looking to terminate the tenancy regardless? That's an important distinction under damage and health hazard cases because it comes with a right for the tenant to cure the damage and health hazard, which can be even after you file a case in some cases. As we've seen equitable power in the courts be used, if a damage or health hazard is repaired, oftentimes the judges are more reluctant to actually grant that relief. But notwithstanding, you have the right to issue a 7-day notice for damage and health hazard. The other thing about that is similar to the unlawful drug notices, that type of action can result in an immediate judgment and an order of eviction to also be entered simultaneously. So if there is absolutely no interest in repairing the issue or fixing the damage or fixing the health hazard, then the landlord doesn't have to wait. We can continue to proceed with that eviction. It's important to remember that it comes with this right to cure. So if you're thinking, now I can live with this damage or health issue for now, maybe you ought to do a 30-day termination for material breaches of a lease as opposed to a 7-day if you complete the eviction that way. That will remove that right to cure issue. Termination of a holdover tenancy or tenancy at will, again, that's the kind that either you don't have a lease or there was a new type of holdover tenancy created following lease expiration. It can be as simple as just accepting rent for the next month after the lease expires. That's what we call a holdover tenancy because you're holding over from the original lease. It doesn't mean you automatically have to leave or there's no eviction. You still have to complete an eviction if the tenant doesn't leave, and that was what was expected at the end of the lease term. But if you accept rent, it can actually create a new type of tenancy. That's actually really important. If you have a tenancy that you're looking to end and you don't want to get into fighting about the reasons, but you just want it to end, serving a notice to quit to recover possession to terminate the tenancy that coordinates with the lease expiration is the safest way to move forward, not letting a new month start or a new rental period start to create a holdover tenancy. Why does that matter? Because if the tenancy is terminating by its own lease terms, it is virtually indefensible with some very limited exceptions. It's virtually indefensible because you're not getting into reasons. You're just saying the lease is ended. That's enough. And as long as a holdover tenancy has not been created, you can still rely on that. And that lives in section 600-5714-1C2. The last one I wanted to mention quickly, and I know I'm covering a lot under the types of tenancy terminations or non-payment cases, we also have physical injury, caused or threatened physical injury. That can be a 7-day assault notice or 7-day notice. It does not apply to domestic violence cases. So if there is a person who is an assailant and a victim in the same home as domestic violence, the 7-day notice would not be appropriate. However, a 30-day notice is very likely appropriate, assuming the lease provisions are prepared for that. When it comes to threatening physical injury, the other component here is it can't be off the premises, right? It can't be a fight in a Meijer parking lot. What we're talking about is an assault or a threat of assault or threat of physical injury that is occurring on the premises. If those things are met, that it's on the premises and it's not domestic violence, then a 7-day notice might be appropriate. To authorize that type of a termination reason as a cause of action, you will have to have notified the police department and letting them know about that issue. If you do notify the police department, then it does unlock that ability of that statutory requirement. The other thing about that is, again, when you get to the hearings and you get to the point of judgment, assuming it's not contested, there's no trial, those types of things. At the time of judgment, we can also ask for an order of eviction to be entered simultaneously. Again, not having to wait an additional 10 days. And that makes sense when you think about it. Somebody who is a threatening person, we don't want them to stay another 10 days to cause more harm before they're gone. But there was a lot covered there, and I can certainly circle back on anyone who has specifics. Starting a case is very simple, and I'll move through this rather quickly. But we have scale forms, which is the state court administrative office approved court forms. Essentially, they took all the fun out of the attorneys who would have to do it all by hand some time ago. But it is useful, it is helpful. Once the appropriate notice is served and has expired, and if the account is otherwise unpaid, for example, on a non-payment case within that 7 days, then you could proceed to court on the basis of what the notice provided. Was it a notice for non-payment or was it a notice for termination? That type of notice just dictated what type of case is going to be filed. So it starts off, like I mentioned in the beginning, what is the relief you're looking to seek at the end? Then work your way back all the way to what type of notice you truly want to provide and what you have the basis for. Once that notice is expired, we'll be able to draft our summons and complaint. A DC 104 is the summons for landlord tenant, comes with a proof of service. And that proof of service is what the court officers use if returned to the court to show how and when those court documents were served. A DC 102A is the complaint for non-payment of rent most people are familiar with. It outlines the premises and the address, maybe a different mailing address if applicable. Most of the time, the premise address is the same as the mailing address. And the complaint will also outline the monthly rental rate, as well as any late fees or other charges that are provided for under the lease. And all of those provisions in terms of other money due are always subject to local court rules and policies based on specific jurisdiction you're in. So for example, some courts will allow you to take $50 a month for a late fee. Other courts will allow you to take $35. Even other courts will allow you to take $0. There's an argument there as liquidated damages. Others find it penalties, and that's the distinction. Again, there's two areas of law that judges have some equitable power in the district court. The first one is small claims court, and the second one is landlord tenant court. Julie?
There a difference in how you fill these things out if you're seeking possession versus a money judgment?
There is slightly. So on the complaints themselves, the top portion of the complaint usually is addressing the complaint for the possession issue. On the very bottom of these forms will be a very small paragraph with almost not enough space, and that'll be what's called the supplemental complaint. So under the court rules and under these paperwork court processes, you're allowed to ask for a money judgment at the same time. Now, there are some additional requirements to make sure you can recover that money judgment at the end. For example, the tenant has to be either personally served by the court officer to have actual knowledge of the case, or they have to appear in court. If one of those two things happen, then they've been perfected in terms of service, and that money judgment that you paid for and prayed for in the very beginning when you filed the case is now eligible. Some courts will prorate the amount of the money judgment through the date of judgment. Others will provide for the full month. You should be prepared for typically proration is what we're seeing more and more. It doesn't mean that the tenant's not liable or responsible for additional rent after the move out, but we don't capture it in the initial LT case at that time. It's just through the date of judgment. So if judgment entered today, it would only be through February, not the full month of February. But you're absolutely correct. So you can join any claims you have related to it. And in fact, we often see in defenses of tenants where everything they've ever complained about gets thrown back as an answer. And that's fine. There may be some grounds that we have to deal with or to triage or to show that there was or was not a legal basis and how to handle that. But what's important is the issue of possession is exclusively in the jurisdiction of the district court. So no matter what they raise, we're going to handle the issue of possession before we deal with anything else, like a slip and fall or something that's, extraneous to a typical non-payment or landlord-tenant relationship. So they're allowed to also join. And my point of that is they're also allowed to join any claims or counterclaims that they may have, but it won't impact or slow down the issue of possession. It could be something that we deal with on the money judgment down the line, but the issue of possession we're going to resolve first. And that's really important because a lot of tenants will essentially, some savvy tenants will set up shop essentially as like a professional plaintiff, and they're doing it from within your home and they're withholding rent and all these things are happening. And we say, well, fight about those other law issues that you think you have, but you're not going to do it from living here without paying rent or otherwise, handling the buildings. So that was a long-winded explanation, but I wanted to get it in because you prompted some great that question. On mobile homes. So DC 102Cs are the complaints to recover possession. This is for termination of tenancies in a non-mobile home. So we're talking about mobile homes located within a mobile home park, not a mobile home that's been affixed to some property somewhere. That's a little bit different. But the mobile homes that are in a mobile home park have a separate complaint form. And that is the DC 102D. It's a just cause termination. And this one's really important too. There's a lot of mobile home parks, a lot of mobile homes out there. And it's important because oftentimes we get property managers from those locations asking us, well, the lease is expired. Can I just terminate for lease expiration? And the answer is no. Even if they're renting both the home and the site, if it is a mobile home and a mobile home park, you must have just cause. in order to evict them. And there is a specific list of what just cause means, based on statute, and that lives in MCL 600, section 5775. Proof of service, I mentioned that before. That is the court officer serving the court paperwork, the summons and complaint, usually a copy of the demand, the notice, as well as any pertinent information. So you don't need to provide the full lease with all the addendums, the pet issues, all of that stuff, unless that is at issue in the case. You would certainly file a copy of the lease, if any, even if it expired. If it's a termination of tenancy case, you may be advised to probably file your guidelines or any sort of policies that are incorporated by lease that may be relevant and pertinent towards the cause of action. But the proof of service that the court officer files back with the court must provide that the summons and complaint was served not less than 3 days before the date set for the hearing. This can be modified by local court rule, but typically 3 days before the hearing is the requirement. If the court officer did not get enough time from the time that the court gave them the paperwork and did not have enough time prior to the hearing, there's a good chance that service would not be perfected. And what happens is the case for the first hearing gets adjourned. So your attorney should work very hard and closely with court officers to ensure that the court personnel are able to timely do their job, as well as the court officer having enough time to do their job and provide the information back to the court or to the attorney's office to file with the court, depending on which court you're in. And those have to be done 3 days before the date set for the hearing. Now, that doesn't mean that the paperwork can't come in last minute. We often get court officers who will give us court paperwork 24 hours beforehand. However, they have at least served the paperwork not less than 3 days, and therefore the proof of service is still perfected. What matters is how the case was served. Personal service, substitute service, or was it attached or posted service? That makes a difference, particularly as Julie pointed out, we have maybe a money judgment we're requesting. If they don't show up and we have personal service, we can take a default judgment, including the money judgment. However, if it's a substitute service, and that refers to somebody over the age of 18 who's not one of the defendants named, then it would not be available yet as a money judgment, for example. Attached or posted service means maybe nobody answered the door, court officer made 3 attempts and tried to get them served, and essentially posted or affixed the paperwork to the property. Court appearances. Again, I mentioned at the beginning, Michigan Court Rule 4.201 is where we live in terms of court processes. Other court rules are still applicable in terms of pleading rules, appellate rights, all of those other things are relevant, but the LT eviction cases live in MCR 4.201. It was amended most recently in May of 2024 by the Michigan Supreme Court. They codified a lot of what we saw during COVID into the court rule. So for example, if you're like me and you were practicing and handling evictions before COVID, you remember those days when you could create a whole stack of cases, 10 to 15 or more at a time. You show up at 1:30 in the afternoon, you talk to tenants, you talk to people, and by the end of that day, you've got everything done and you've started your 10-day clock. That is no more. That went away during COVID, during the emergency orders. And then what they determined was that the Zoom appearances and the efficacy tenants were getting by being able to appear by Zoom and having additional rights read to them, the rental assistance that became part of the processes, all of those things and more contributed to the reason why it was codified into our court rules. So at this time, we're going to have a very different level of procedure than you may be used to if you haven't done a case since COVID. For example, at the first hearing, the tenants are advised of all certain rights. They show up and they're advised that they have a right to an attorney. If they can't afford one, Legal Aid of West Michigan or others may be available to provide free or discounted legal services. They also have a right to a jury trial. They have a right to rental assistance and more. And so those rights are explained to the tenants at the first hearing. And if they show up, with very limited exceptions, there will typically be a second hearing set. And it's at that second hearing that more work gets done. Cases are typically resolved in 3 ways in landlord-tenant. Obviously, consent of the parties, by judgment or conditional dismissal. You could get a default or dismissal if a party fails to appear. And of course, if it's a contested case or there's genuine tribal issues, we'll have a hearing or trial. Again, tenants have a right to legal assistance and to apply for rental assistance. The summons and complaint that you provide in the court documents are sufficient to start that process with the local coordinated rental agencies, the HARAs, trying to find a way to get rental assistance, either through Department of Human Services, Salvation Army, or others. Each county here in Michigan has their own local coordinated entry agency, or PARA, that can be used to facilitate rental assistance. The notice you send for non-payment is not sufficient. You do need to start with a summons and complaint in order to start that process for emergency rental assistance, such as Department of Human Services State Emergency Relief, or SER. That's the most common one we hear. Motions for judgment under the court rules may be appropriate if there truly is no genuine issues of factual dispute or legal dispute, which are heard pre-trial. Attorneys request interim orders under MCR 4.201I, which can include escrow or court-ordered rights to enter the property. For example, if a tenant is withholding rent or they're refusing entry for inspection or repairs. Oftentimes we have system-savvy tenants who will complain about repairs and then also refuse entry for inspection or for the landlord to make those repairs. And they like to leave that out while they're withholding rent. So it's a great way for us to be able to get in there, inspect, make those repairs, and ensure that the property is compliant with the law so you can proceed to go capture that rent. One of the questions I often get is, what is the difference between a possession judgment and a money judgment? The possession judgment side of things is the right to recover possession of the property. For example, in a leasehold, you're granting a possessory interest in the property. They don't own the home. They're granting a possessory interest. And you have to extinguish that possessory interest. And that's why we call it recovering possession. In a non-payment case, it is also the right for the tenant to pay to stay in possession of the property. And they have at least an automatic 10-day timeline after the judgment's entered to redeem possession. That is a statutory right, and it's actually based on the appellate rules. In a termination case, it is the right for the tenant to move out to avoid an order of eviction. In most cases, the 10-day timeline still applies. I mentioned at the beginning, there's a few exceptions for the type of termination. But if it's a typical 30-day termination for perhaps breach of lease or the end of the lease, they're still going to get their 10-day timeline. And again,
So when they just move out, it doesn't show up in their history.
That's right.
So if we're screening tenants, it doesn't mean they haven't been like evicted. Just means they got the heck out of there.
That's right. That means they vacated before that order of eviction entered, and that's the part that can affect rental history.
Oh, that's
Absolutely
interesting.
right. Yep. Now, the supplemental complaints and money judgments, as we're getting to here in a moment, those can also show up on your credit reports. So there can still be adverse credit history impacted for money judgments. So it really becomes a tactical decision for a lot of landlords. Do I just sue for possession? And if I have to recover possession and there's damages or rent owed beyond wear and tear and unpaid rent, I'll just go ahead and file a small claims action. I'll capture it all at once. Or do I want to get the supplemental complaint and now capture what I know I can capture now? And then if I can't find my tenants or there's some issue, then I'll deal with it down the road. Or if there's substantial damages, I'll still sue in small claims for anything I didn't recover in the landlord-tenant case. And that's just a tactical decision based on your specific scenario and cases. And you should definitely talk with a landlord-tenant attorney if you have to ferret that out, what makes the most sense for you. The money judgment portion is the amount that is owed as of the entry of judgment. As I mentioned, typically those are prorated. Some courts, again, will give you the full month, but be aware that most of the shift now is happening towards proration. And if that amount is unpaid, it remains owed, even if the tenants move out. And that is the biggest distinction between the possession judgment and money judgment. If you have a possession-only judgment and they don't pay and move out, that is not a judgment that you can take to your collectors. You would need a money judgment in order to go to your collectors, or at least to secure it with a money judgment. The same complaint form is used. We just have the very bottom of the form called supplemental complaint. That's where those details are for pleading for the supplemental complaint. And there are some court rules that allow you to make certain amendments, some with the court permission, some without court permission, all the way up to trial. You can always add newly discovered information. For example, if you just sued for one thing and then you get in and inspect and you find a whole bunch of other things, that doesn't mean you have to start a new case. We can amend and file a new supplemental complaint that now includes a lot of newly discovered information. So don't think that once the case is open that you're stuck. There is some flexibility in being able to add on and seek what is still due and owing under the tenancy. And there is a particular statute under judgments that talks about the amount due in arrears or at the time of trial, including other money due. And that lives in MCL 600-5741. An order of eviction, the DC 107, is filed based on the possession judgment. It's not based on the money judgment. So to get an order of eviction, you will need the possession judgment. The DC 107 is the part that we do not typically require an additional court hearing. with some exceptions. For example, if a motion to stay is filed by the tenant, or we also see by local court policy that judges who see substantial payments may, on a non-payment case, may still ask for a hearing prior to issuing the order of eviction based on those substantial payments. Again, that's the equitable power that the judges have. They can choose to just sign it as is, or they can choose to have a hearing on it. I also mentioned the 56-day rule here on my slide. That lives in MCR 4.201M. And what that stands for is actually following the entry of judgment. While we talked about the minimum 10-day stay period, you actually, as a landlord, have more flexibility. Now that you have the leverage of a possession judgment, you can choose. Do you want to work out a payment plan? Great. There you have up to 56 days in order to seek out and apply for that order of eviction without an automatic hearing. So I want to be clear, you can still go beyond 56 days in some scenarios. For example, if you had a 120-day payment plan and that worked for you, that's fine. The issue, though, is that if the plan falls apart, then you'll need to file a motion in order to ask the court to sign the order of eviction. If you do it in less than 56 days, that automatic hearing requirement is not required. So we always mention that. There's also an additional 56-day rule. Even after you've applied for the order of eviction, the judge has signed it. The court officer can go visit the property and post it for the final 24 hours. At that point, the court officer is actually coordinating with the landlord and determining, when am I coming out to complete this eviction, or would you like to see something else happen? You'll be surprised to learn that a lot of cases still get resolved even after we seek out the order of eviction. We'll allow a last minute payment from the landlord, or something like that will happen, and they'll say, go ahead and halt this eviction. So you got the initial 56 days after you enter the possession judgment to apply for the order of eviction, and you even have another 56 days in which you need the court officer to execute it. So again, they will serve it, but you have another 56 days in which to execute it. A lot of flexibility built in. And so when we get the question of, well, should I wait to see what happens with my tenant, to see if they'll come up with this tax return payment or settlement of a lawsuit, there's usually something that they're waiting for. And the landlord is wondering, is it worth my time to wait? Well, typically the answer is, I wouldn't wait. I would get the process started, go all the way to judgment if needed. We have an agreed upon amount that's owed, and the leverage is now in the possession of the landlord to decide whether to use that lever to get the person out or to wait. And those 56-day rules at the end will allow for some flexibility there. And you can kind of bootstrap a little bit better at that point. The main thing is that the landlord then is still in possession of that leverage, and that's important. Because if the deal falls through, the settlement doesn't happen, the tax return was intercepted by another garnishment, things happen. And then you have to start all over and start those processes. So we always say don't wait, because you always have that flexibility later on down the line. Is an eviction order, we were talking about the order of eviction, is it still valid if a defendant has paid the judgment but still has a current balance? The answer is no. If the plaintiff accepts money to satisfy a non-payment judgment, then the judgment is satisfied. The landlord can reissue a new notice and start a new case. The goal of a non-payment case is to bring the account current, not to disguise it as a termination case. But there is a caveat here. After the 10-day period that I mentioned before, the statutory period of redemption in which the tenant can repay to stay, a landlord outside of that 10 days does not have to work with the tenant and can proceed with the eviction. Though many
You can turn down a payment is what you're saying.
You can choose to refuse payment. I think ultimately it depends on the situation. For example, the tenant's not without recourse. They can go to the court, they can file a motion to stay the eviction and accompany it with 1 month's rent and stay the eviction. Show up to court and explain, Judge, I have this money ready to go. I have you have my 1 month escrow to stay this eviction, and that will work to stop the eviction process from the tenant's side. That's their water to carry, but that's their recourse. So it's important that you understand that they do have that option as tenants to resolve it, and they can provide money to do that. In some cases, they can also ask for a waiver of the court to even not put up 1 month's rent of escrow and still get a motion to stay, to much consternation of the landlords, as you can imagine, because now they're not even securing the stay. And they're trying to determine, is this a performing tenancy or a non-performing tenancy? All I see is a time delay, right? So we do see those issues. So it's important to remember that many cases, again, are still satisfied after that order of eviction is issued or served even. And so no physical eviction is ultimately required. Even out of the thousands of cases we do, we average maybe 3 to 5% that actually had to go to a forcible eviction, where it wasn't already worked out through the process, where they were going to move out on their own or something like that. That's about 3% that actually go to a physical eviction, which is good. I'm going to go ahead and move on now to duties owed to a tenant from the landlord. And this is involved, whether it's written in the lease or not. In Michigan, every leasehold has an implied warranty of habitability. And that is a warrant of habitability of fitness and a good repair. It lives in MCL 554.139. Premises and all common areas must be fit for the use intended for human habitation. For example, in a residential tenant in a setting. The premises are kept in reasonable repair and in compliance with applicable state and local health and safety laws. So those are things like your permit to be able to house, to be able to rent, your rental permit. The compliance with the building codes and the property maintenance codes and the zoning ordinances and those types of things all have to be in good standing. Otherwise, you're leaving it open for possible defenses and delays in your non-payment. Plus, you might even get fined by the city, depending on what the issue is. Tenant accountability. The International Property Maintenance Code holds tenants accountable and responsible for those portions of the premises within their control. That's where the duty is not with the landlord. So, for example, housekeeping, trash in the basement, impediments to an emergency exit, pest and rodent infestation brought in by the tenant, like bed bugs and other things we see. But getting the municipality to cite the tenant is another matter altogether. There was a lot of questions about who is responsible. But under the statutes, the tenant is accountable for those things. Additional duties owed to a tenant. The tenant is protected from retaliation. And there's a presumption of retaliation if some of these behaviors happen within 90 days. And that lives in MCL 600, section 5720. Landlords cannot evict if a tenant is simply securing their rights under the lease or laws. So if they're trying to assert a right that they have and you terminate for that reason, that's clearly retaliation. A tenant complaining to a government authority, such as the housing department. Tenants joining a tenant's union. Tenant's breach of lease. If the landlord increases lease obligations for any of those above activities, would obviously be a retaliatory measure. Tenant's non-payment of rent if the landlord has breached the lease. And that typically refers to the implied warranty of habitability or some other major duty that was owed as a material part of the lease that wasn't followed through. Then the tenants may be excused from paying rent. Additional duties owed to a tenant, no lockouts. This is very important. Landlords cannot attempt an eviction without following the proper legal notice and complaint procedures. You can't turn off utilities, remove doors, or otherwise make the property uninhabitable. We've had situations where we've had landlords put rotten meat in a refrigerator downstairs and unplug the refrigerator. We've had introduction of super loud noises from neighbors who also was the landlord living nearby in order to create an uninhabitable situation, and lights and other things to make it uninhabitable. You can't use threats or force. You cannot change the locks or board the building or otherwise barricade the premises. You can't remove or destroy the tenant's property. As I mentioned, you can't introduce noise, odor, or other nuisances. It violates the tenant's right to what we call quiet enjoyment. The word quiet enjoyment has a couple different meanings under law, but in this particular case, we're talking about the use and enjoyment peaceably in the premises. And certainly, you cannot attempt to evict the tenant within 90 days after they have filed a complaint with a public authority. Even if it's completely unrelated, there is a presumption of retaliation that will have to be overcome. You can still proceed with your case, but proceed with caution, because there'll be a presumption you have to overcome. And it's very important to make sure that you are correct. We'll move on a little bit now and talk about leases and security deposits. There are some laws regarding leases and security deposits. Obviously, Michigan contract law and the case and common law that goes with it. We also have the Truth in Renting Act, as I mentioned in the beginning. The Landlord-Tenant Relationships Act, which is sometimes colloquially known as the Security Deposit Act. And of course, we have in Michigan, for residential purposes only, the Michigan Consumer Protection Act. And that's very important because failure to return a security deposit timely and promptly can expose you to the Michigan Consumer Protection Act violations, which has some serious teeth, including all of the tenant's attorney fees. They can get very expensive very fast in violating the Michigan Consumer Protection Act. In the Truth in Renting Act, we talk really more about what language is in the lease. It doesn't have a lot of teeth in terms of doing something wrong. Typically, it's a $250 fine, but now you have to change your leases and put it on, and fix those issues. It controls what cannot be in a lease, and it controls what mandatory language must be in a lease. So it does both. It provides provisions for tenants to terminate the tenancy early with certain conditions. There are penalties if the provisions of the act are not followed, and I mentioned them a moment ago. Typically, it's $250 per instance. And of course, if you're on notice of that defect and you do not change or alter that, it can increase your penalties because you were on notice that you had some problems and chose not to make those changes, either by removing prohibited language or by not including the mandatory language. So prohibited provisions. What cannot be in a lease? You can't put anything that waives the rights to conditions of the premises. So you cannot rely on an as-is clause in a residential tenancy to protect you from the implied warranty of habitability. We talked about that a little bit ago. You cannot put anything in there that waives any rights regarding the security deposit. By statute, the security deposit is the rightful property of the tenant until the landlord has established a lawful claim for it, and there are many ways in which that can be done. Obviously, these statements violating fair housing laws like discrimination based on race, gender, ethnicity, national origin, and now coming soon, April 2025, statewide, based on source of income. So they call confession of a judgment. That's essentially a way to try and automatically get a judgment by bypassing the court process is not allowed. You can't put anything in a lease that will exculpate a lesser from duties imposed by law. So again, you can't say I've waived my right to comply with the implied warranty of habitability. You can't do that. The one we see most often and sought after and argued is the liability for legal fees in excess of those established under law. And this is kind of a big deal. And that's because in typical general civil litigation, it's not uncommon for your lawsuit to come with the right to recover certain damages and amounts or any other relief, and also my attorney fees for having to bring the case and do this. That is not an uncommon thing. However, in Michigan, the statute about how much you can receive and assess to the tenant towards your legal fees is set by statute. And it is low and hasn't been updated in many, many years. And we'd love to see somebody in Michigan update. It's been 40 years, I want to say, since they've even updated that provision. So we're talking about only your out-of-pocket court filing fee. We're talking about your out-of-pocket court officer service fee. And we're only talking about $75 towards your attorney bill, assuming there's no trial. And if there's a full-blown trial, you only get $150 out of the tenant. So you could pay your lawyer thousands of dollars to go run a full hearing and a full case, but understand you won't be able to recover those amounts for your attorney fees. And so it creates a situation where the attorneys you're working with need to know time is of the essence. This is not going to be a big return on investment. The best thing we can do is provide you value by clarity, transparency, and expeditious processing of the case. Time costs money. That simple. Continue on with prohibited provisions. You obviously can't provide some sort of security interest from the landlord in the tenant's property by way of a lease. You can't accelerate rent payments. Now, there's a little bit of an exception to some of these things, but they're highly disfavored. Accelerated rent payment provisions are highly disfavored. There is a certain statutory way that you can word it, and it has the same effect. So I want to go ahead and address that now. If you have an accelerated rent payment provision, it must come with another statutory required provision that explains outright that the landlord does not relieve themselves from the liability of mitigating damages. They have to mitigate their damages still, even with an accelerated rent payment provision. So there is specific language that must accompany that accelerated rent payment provision, or it will not be worth, it'll be worthless. And in violation of the Truth in Renting Act, perhaps. Obviously, you can't waive eviction or possession rights by saying in your lease, I agree to move out immediately upon notice. That would be giving up the processes that are defined by a statute in the court. Again, releasing the landlord or tenant from mitigating damages. I mentioned that a moment ago, specifically in the context of the accelerated rent payment provisions that we often see in the statutory requirements to keep that language appropriate. But you can't do anything that releases a landlord or tenant from mitigating damages. That is a common legal maxim that no matter what you're dealing with, you have a duty to try and mitigate your damages. So, for example, in a landlord situation, if somebody moves out, early breach of lease, and you still want to hold them accountable for the additional months that are owed, you have to show the property, you have to list it, you have to do other things to try and mitigate your damages and try and re-rent the property before those additional damages are appropriate. If you make no effort and you show all your other units except for this one, and you're going to sue this tenant for all of those months, you're going to find a very difficult time recovering all those amounts. Obviously, any provisions that violate Michigan consumer protection laws can't be waived. Any provisions that require the tenant to give the landlord power of attorney or something like that, that can't be in there. And of course, any provisions enabling changes to the lease without proper notice. There are some items allowed, but we are always paying attention to those provisions as well. I'll quickly go through these 6 mandatory provisions. For example, you got to have the name and address where the tenant can send notices under this act. That's not uncommon for everybody to have on the first page, where the landlord's contact information is and where to make payments, as well as where to send notices. And the tenant's information will be on there as well for the same reason. Excuse me. The name and address of a financial institution where the security deposit is being held, or surety if you've got a bond for security deposits, and where that's been lawfully obtained. If a landlord uses the security deposit to pay expenses, they must obtain a surety bond in the amount of the deposit to ensure that the security deposit is still available to return to the tenant as required by law. There is some notice language, like the following notice in a 12-point boldface type. And I italicized it for this slide. Don't copy and paste it. But it's at least 4 points large in the body of the rest of the lease agreement. And it says, you must notify your landlord in writing within 4 days after you move of a forwarding address where you can be reached and where you'll receive mail. Otherwise, your landlord shall be relieved of sending you an itemized list of damages and the penalties adherent to that failure. We'll get more into the Security Deposit Act relationship soon. It's kind of a ping pong or tennis match of rights and obligations. But for purposes of right now, this is simply a requirement that you have at your lease, this language. And of course, the one you see all the time is the following notice in at least 12-point boldface type. Notice, Michigan law establishes rights and obligations for parties to rental agreements. This agreement is required to comply with the Truth in Renting Act. If you have a question about the interpretation or legality of a provision of this agreement, you may want to seek assistance from a lawyer or qualified person. A couple more notices that may not be as familiar, and you do want to check your leases to make sure that they are updated. We have a notice as it relates to senior citizen housing, and where you may have an elderly tenant who is now qualified to go move into a senior citizen housing situation. There is a required notice that allows that to happen without being deemed a breach of lease. If you have occupied your rental unit for more than 13 months, you may terminate your lease by a 60-day written notice to the lessor if either the following occurs. A, you have become eligible during the lease term to take possession of a subsidized rental unit in senior citizen housing, and provide the lessor with written proof of that eligibility. You have become incapable during the lease term of living independently as certified by a physician in a notarized statement. One of those two things happen, you're allowed to be released from the obligations of your lease, and there's a notice requirement and some criteria for that. There's also a domestic violence provision, and it simply says, and this lives under MCL 554.601B, and you can include an amendment to the same effect I mentioned in my slide, but a tenant who has a reasonable apprehension of present danger to him or his or her child from domestic violence, sexual assault, or stalking may have special statutory rights to seek a release of rental obligation. Now, that particular statute outlines exactly what is required in terms of both the notice, how it's sent, for example, certified mail, has to be in writing, and it has to be substantiated, typically with a PPO, police reports, and some other documentation. So just simply sending you a notice saying I have a domestic violence situation is not enough to relieve a tenant from the statutory obligations of the lease, which means they still have to pay rent. And when it takes effect is usually 30 days following which the notice was given. So they may be on the hook for even one more month of rent before they're actually off the hook for the rest of the lease. When such a situation happens, any other leaseholders still remain fully liable and responsible for the duties of the lease. It does not extinguish the whole lease. It just removes that individual from the joint and several liability implications of your lease. The other leaseholders remain in full force and effect. A little more with security deposits. A security deposit may not be more than 1.5 times the monthly rent. If you are taking more than 1.5 times the monthly rent, you are in violation of the law, and you should correct that as soon as possible. Again, notice that the lease where the security deposit is held, we mentioned that a moment ago. A notice must be given in the lease. We talked about that, of where the funds are being held. Or if the funds are being commingled for other purposes, then the funds must be bonded, and a statement to this effect is made in the lease. So again, we talked about that, either the financial institution or where the bond information is. Security deposits, highly recommend by statute, in order to show causation of damages under the LTRA, under the Landlord-Tenant Relationship Act. You have to show causation somehow, and that's a statutory remedy. So the statute has an inventory checklist requirement. Inventory checklist must be given to the tenant at the time of the lease signing, and a copy of the same inventory checklist should be used to inventory damages after the tenant has vacated the property. So you typically see good when they move in, and not good, when they move out to certain items. And that will show causation. That gives the tenant an opportunity to self-check their own damages in their property. And then, of course, any damages beyond normal wear and tear can be attributed to the tenant. Question?
Yeah, if you didn't, like we have often where we'll take over a lease from somebody else and don't have that inventory checklist. Does that mean we can't take any of their security deposit for damages?
So you still reserve, there's a case called Hovenesian versus Dom, and it still stands for the notion that you are still entitled to your common law remedies for damages and actual wear and tear. But to answer your question, if you're taking a security deposit, you need to use the inventory checklist. Yep.
Yeah, some of these we've inherited and it's just not available. You can tell there's damage. Like there's no way they lived there the whole time with the house like that.
Right. So you'll still have your common law remedies for damages that you could still seek out.
Which means small claims?
Well, no, it could be in a supplemental complaint in your eviction case still, if you have damages beyond wear and tear. You have a proof problem because how are you going to show causation necessarily? They have a better argument that no, those were like that. So sometimes the best thing you can do is stop the bleeding and still issue the inventory checklist as soon as possible. Hey, I don't have this one in my file. Can you go ahead and make a list of this? And that'll put you on notice if there's any sort of significant issue. You want to know that. No heat, whatever the
So it
issue
doesn't need to be dated the same day as the lease. You can do it whenever.
You should do it whenever in that situation. But the best practice is obviously when you're first initially leasing, you need to do the inventory checklist upon move-in. Typically within 7 days, it needs to be returned.
Sure.
But your example was why I inherited kind of a not perfect file here. What do I do? I still recommend if you're going to keep the security deposits that you provide the inventory checklist.
Okay.
Yeah.
That's great.
At least you have a ground zero somewhere.
Mm-hmm.
Yeah. Great question. So I mentioned there was a ping pong of rights or like a tennis match, however you want to look at it. So again, the way this works is you have this language that says within 4 days of moving out, you got to provide my forwarding address. So the first obligation starts with the tenant when we're talking about security deposits. So we're talking about when they move out and whether you have to return it and how that would work. So within 4 days, they give you a forwarding address. This is where you can send my security deposit. All right. By providing that that notice within 4 days, now the obligation switches to the landlord. They have now only 30 days. Now they can do it faster, but they have up to 30 days after termination of the tenancy or after the move out and after they've received that 4-day forwarding address to provide an itemized list of damages. So typically you're talking about your move out checklist and comparing what's due and what needs to be repaired. And maybe your maintenance people are already in there making repairs and you're creating your itemized list of damages. You're taking pictures. You're doing those things. Even if, and I don't know if this is coming up on a slide, so I want to make sure I have it right. Even if they don't provide you the forwarding address, most landlords' best practice is to still create that itemized list of damages, that notice of damages, and put it in their file because they don't have to come back later and try and recreate it if you have an issue down the line outside of the typical processes for landlord-tenant relationship act. But if they don't provide the 4-day forwarding address, it does relieve you from the penalties or forfeiture elements of the security deposit that could happen if you don't provide that 30-day notice. So let's say they did the notice and you provide the itemized list of damages. There'll be a little statement on there, typically on the correct way to do the itemized list of damages, say you got 7 days to respond. But by law, that's true. They have 7 days. The tenants have 7 days from receipt of that notice, the 30-day notice, the itemized list of damages, to respond in writing, not on the phone, but in writing with that disagreement. I contest blah, blah, blah. I'm not responsible for that. It was normal wear and tear, or there's no way you had to charge that, whatever the disagreement might be. Or the amount was exorbitant, right? Whatever their disagreement is, they have to respond within 7 days. If they do that, and so far step 1, 2, and 3 have been met, then the statute provides only 45 days, again, from the termination date, which means the move out date, in which the landlord must sue. So we've already had 4 days, 30, we're at 34, 41. You could be only in 4 days between the time you received your notice from your tenant objecting or disagreeing timely to the notice of damages. And now you only have a couple of days in which you need to actually either return the deposit and sue for it later, or file right now and sue either in small claims or general civil if you hire an attorney.
Is there relief if it takes you longer than 30 days to figure out the extent of the damages?
Yeah, great question. So I think that even if you don't have the total calculation of damages done, like you don't have your estimate back from your house person or whatever, you should still send out the notice of damages saying, no, all the copper in my plumbing is stripped, waiting on estimates, right? But we're keeping your security deposit because we know it's definitely going to be more than your $750.
We had like pet damage before that once we ripped out the carpet, we're like, oh, there's more here.
Yeah. So, and the other thing to keep in mind is what is actual damages, right? So one of the common mistakes we actually see people make is that they think cleaning is damages. And there's cases right on Point, Michigan that say cleaning is not actual damages. So you don't want to charge cleaning fee costs out of your security deposit. You can still sue for them, right? But it won't be under the security deposit. There's only permissible uses.
I did not know that.
Yes, that's an important one. You may fully think you're able to keep your security deposit of $1,000. 200 of it was cleaning, 800 for something else. You technically wrongfully withheld $200. And if you do that, you could be liable for what they call double damages. So you'd actually have to offset $400. So yeah, we want to avoid that. And the notice of damages is not required. We're talking the 30-day itemized list of damages if the tenant does not provide that forwarding address within that 4-day period. Again, if it's outside the 4-day period, best practice is to still issue the itemized list of damages, still follow that process. But you can rest assured knowing that you're not in violation of the LTRA. And of course, the amount of the security deposit being retained is for past due rent only. That is an exception to having to create the itemized list of damage within 30 days. I mentioned it's still a good idea to send out the notice of damages if any amount is kept, even if the tenant does not give a forwarding address. That'll save you a lot of headaches later. And there is a specific exception, and it lives under 613 subsection 2. And it talks about if the entire amount is attributed to rent, then you don't have to, you didn't violate the LTRA by not filing within 45 days. So typically past due rent would not account to accelerated rent. It's only the past due rent. Yeah, we talked about a couple reasons for termination of tenancy. I won't spend a lot of time on this because I've already hit this pretty well, like non-payment or lease violations. Again, not related to drugs, health and safety, destruction of the unit, drugs, threats of violence perpetrated by a tenant or guest upon other guests, neighbors, or the landlord. Trespassing can also be handled by summary proceedings, but it is not a termination of tenancy case. So you still have to, quote, complete an eviction if there is people squatting. Now, whether someone is squatting or has residency is a factual question. So when in doubt, follow typical procedures. You can issue a 30-day notice to quit, all occupants of blah, 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 and you can take the slower but true method of getting them out. But if it's a true squatting situation where you were there yesterday and now they're there today and they have no business being there and they're withholding everything by force, you can actually tee up a summons and complaint without notice. You can actually seek to have the first hearing and get them out immediately without notice. Who would you notice? You don't know who's in there. They're squatting. Again, the notices we talked about in terms of non-payment, they're 7 days, terminating tenancy or 30 days, expedited termination in some cases may be eligible. There are implications for collecting rent after notice, and this applies for non-mobile homes. So mobile homes and mobile home parks, they have a statutory right to keep taking rent before, during the proceedings, before you file the proceedings, after the proceedings. It will not prejudice your termination case in a mobile home. However, for non-mobile home cases, then we have what's called the park forest rule here in Michigan. And that stands for the notion that if you accept rent for any day past the expiration of your 30-day notice to quit, there is an actual presumption that you are not going to move forward with termination. And so it's a very well articulated rule, and it constantly is the bane of landlords' existence because they thought they were trying to accept the rent for a good reason, and they actually have to defect their notice and start over again for the 30-day. It can also lead to dismissal of the case. Now, in some cases where money is coming in automatically, you didn't have a right to withhold or refuse it, you can quickly refund money and argue that it was not deemed accepted. We've seen that done to try and argue, no, this came in, I didn't initiate it, it wasn't something I wanted.
Especially Section 8.
Section 8, exactly. And actually, I'm glad you mentioned that, Julie. It's important if you have a Section 8 termination happening, number one, you have to have good cause outside of just lease expiration. You have to have good cause. So typically that there's specific reasons that MISH allows in their HAP contracts. What good cause means, like other reasons is very common. Material breaches of lease, right? Those types of things. But you're right. When you serve up a termination notice and you're providing it to the tenant, it's very important to also provide that termination notice to the Section 8 people, or maybe the caseworker, people working on those cases. That way they know to stop those payments. Now, I have seen cases where they purposely forward payments to the landlord, and that will require some sort of process on the landlord's end to try and either refuse that money or reissue the notice. And again, get on the Section 8 worker saying, I just had to reissue my notice, right? Please stop sending this payment. Try it that way. So there's a couple ways to handle that situation, but providing notice to both the tenant and the caseworker is going to be your best chance to try and stop those types of payments. Section 8 is a great point, Julie, because a lot of those come in batches.
Yeah.
And then you don't even know. Right? Exactly. And so that can create complications. But the tried and true method is to provide plenty of notice, more than 30 days if you can. Provide it to the Section 8 worker so that they can put the brakes on the voucher payments. And again, we've got the summary proceedings, which are always in the district court. We get a writ of eviction or an order of eviction, sometimes called a writ of restitution. But the order of eviction is what actually removes them from the property. And that's when the court officer can come out and deem personal property remaining in the unit abandoned. And under the direction of the court officer, the landlord or maintenance team can remove personal property to the curb. And under the direction of the court officer and supervision, they can change locks and recover possession at the end. Collecting on judgments, that comes under the supplemental complaints and money judgments. If you have any questions about how to collect on money judgments, we can help with that. I'd like to talk about the anti-lockout statute exception, which is where the death of a tenant lives. So it's in the same statute that says you can't introduce odors, you can't do these things, you can't lock them out. And it actually is a whole carved out exception, and it's for the death of a tenant. Now, specifically what we're talking about is a sole leaseholder, all right, not a joint tenancy, typically a sole leaseholder. Now, hopefully your lease has something in there about an emergency contact, or you have some information about how you can contact, next of kin, family, some emergency contact. If you don't have an emergency contact provision in your lease or application, definitely get that up to speed, because you may have the situation where you have a sole leaseholder die, and now you're saying, what do I do? Well, you can't complete an eviction case because you can't sue dead people. You can't sue dead people. So you have to find another way. Well, the statute exception carves out that process. Now, I'd said there's a complicated set of written notices. It's not complicated if you've done it for a while, but if you read the statute, it can appear very complex. In short, if you have someone who dies who's a sole leaseholder and you get in touch with their next of kin or an emergency contact, you can ask them, do you plan to open up an estate? They're not required to, but you would want to ask that. Do you plan to open up an estate? And just document their answer. Yes, I do, or no, I don't. Okay, very good. Now, if the account is delinquent and the person has been deceased for more than 18 days, and the account is now past due, then it is right to basically create what we call this county administrator letter. So we write a letter. You'll keep a copy of the Kent County, for example, if it's Kent County Public Administrator letter. Keep that in the tenant file, and it actually provides for a notice that you will affix to the property. And it says something to the effect of, hey, if you don't respond to this letter, we're going to be able to go to the unit, and in 10 days, we're going to be able to clear it out. And so if you have the letter, sent out, you have all your documents in place, you've affixed the correct timeline on the property, then you can go and you can take everything out. Items of value they want to consider storing in a typical storage warehouse. A lot of landlords might have a self-storage unit or something where they might collect things that might be more expensive, and they're wondering if the tenant's going to come back for it. That's always fine to do it that way. If an estate is open, or we get a letter back from the county administrator, which is, it's possible, it happens, then it's actually not a bad thing. There's actually a probate way to handle that. And so essentially the county administrator may be the one who's taking on the duties of like that probate administrator to be able to say, okay, I've got in touch with family and we're going to get this stuff cleared out here. And there's a few more things with that. You can talk to estate planning attorneys about probate, some of those things, all of which we do in-house. But the good thing about that is it can be done in 30 days or less. So you don't have to wait for the full hearings where nobody's going to show and you're just waiting to go through your own processes. This is a much more tried and true method of dealing with a sole leaseholder who's passed away. My last few slides here, I've got about 3 slides left. I'm going to mention quickly land contracts and land contract forfeitures. I bring these slides up because even though it's not the typical landlord-tenant type cases that you see, we're dealing with land contracts. What we're talking about is seller finance properties. So the tenant doesn't actually have legal title until the full contract is completed, i.e. that the account has been paid in full, that the contract is complete. After which time it merges what we call equitable title with legal title. So once the contract is properly completed, i.e. paid in full, then and only then do the tenants now become homeowners and they now own the land. It could be vacant land, it can be property, it can be all sorts of things. But we talk about forfeiture in this context, but we're talking about when people either don't pay, haven't paid, or have problems. Forfeiture of a land contract property and recovery through summary proceedings, very similar to landlord-tenant. They're only permitted if the contract itself gives you the right to declare a forfeiture. Really important to make sure your land contract has it in there. And it has to be because of the vendee's non-payment or other material breach. If you don't outline that specifically, you may find yourself stuck in a land contract and nothing you can do about it in terms of forfeitures. You can, in fact, collect rent during the proceedings and during the period of redemption, but nothing after forfeiture. In other words, once forfeiture is complete, you can't ask for any other amounts of money, but you don't have to give back any of the money that's been accruing and earned during the land contract. It doesn't matter if you're in your 19th out of 20th year. You don't have any refunds required in some cases. There's no right to accelerate land contract payments, even the contract expressly calls for acceleration. That's important. Unlike the other types of things where you can have certain statutory language, and you have this duty to mitigate damages, land contracts say, no, you cannot accelerate. It starts with a notice. You have a DC 101, and now you wait, instead of 7 days, for example, now you wait 15 days, unless it's otherwise extended in the contract. You always follow the contract terms. You can serve the summons, in this case, it's a DC 104A, with a proof of service. Sounds very similar to landlord-tenant, and a complaint. You appear for court, you attain a judgment, just like LT cases by way of summary proceedings. And that's the similarity between landlord-tenant and land contract. The difference here, of course, is the redemption period. I mentioned in the landlord-tenant context, there's a 10-day statutory period. That's carved out by statute. But like a mortgager, a land contract vendee has a period in which to correct the default. If, for example, the vendee paid less than 50%, then they only get a 90 days from entry of judgment period to redeem. If the vendee paid more than 50% of the value of the land contract, then they have 6 months after entry of judgment to pay. So if the judgment is paid within one of those redemption periods, you cannot seek an order of eviction or writ of restitution to have it removed. But if the vendee pays any of the judgment amount within the redemption period, then there must also be a hearing before an order of eviction may be issued. And a vendee that loses the property under land contract forfeiture, again, is not entitled to recover amounts paid under the land contract, and those amounts are deemed forfeit. At that point, any future amounts are not accessible to the owner, but they don't have to refund any of the amounts paid. That's a big deal. A lot of people get to the very end of land contracts, and that's where we see a lot of their disputes. I'm going to close here talking about upcoming changes effective April 2nd, 2025. Michigan Senate Bill 205, 206, and 207 was signed by our Governor Whitmer on December 31st of 2024. Now, if you are in a municipality like Grand Rapids or other cities that already have had similar ordinances, this isn't a huge change, but it is now statewide. And among other things, in short, a landlord cannot discriminate now based on source of income. It is creating a source of income class as a protected class in the very same way that we protect race, ethnicity, national origin, and all of those other important civil rights categories. So source of income means what? Well, if you have an otherwise qualified tenant, but they have Section 8, you say, I don't want to participate with Section 8. Did I just discriminate based on source of income? Maybe. Very likely, yes.
Can you participate with Section 8, but say, I'm not going to do whatever repairs they require?
If you participate with Section 8, you are beholden to the HAP contract.
But you have to under this law. So you can't say, well, I don't know.
So here's where it gets interesting, Julie. I'm gonna get a little bit more technical on this because this is a great question. So for example, does it mean that if Section 8 comes to me and says, you must sign my HAP contract? No, you don't have to sign that HAP contract.
Mm-hmm.
See the difference? However, if the housing choice voucher in Section 8 people say, despite that, and this does happen in some scenarios, most of the time there's always a HAP contract in order to get payments. In some cases, we've seen it where a landlord's like, I'm not signing away my rights. I'm not signing anything under this HAP contract. It completely changes the way I want to do things. From 7-day notices to 30-day notices. It changes things substantively, even though it's a process thing, right? So I'm not going to sign that HAP contract. However, A landlord cannot refuse any payments made from that source of income. So if they say, okay, I see you're not signing this, but our tenant has a portable housing choice voucher and they're going to live there, and here's the payment. If you say, I'm not taking that payment, now you have discriminated. You have to take that payment. See what I'm saying?
Yeah.
Now, if they contest and they say, this is a Section 8 tenancy, and okay, show me my signed HAP contract. Oh, we don't have one. Great. We win. Right. So that's how I've seen it very technically played out as a tip and a trick. However, a lot of people don't have problem with Section 8. I mean, it's guaranteed payments. I mean, there's a lot of great things about Section 8. So I think by and large, most landlords want to accept it, want to participate in it, but need to know, oh, I can't issue 7-day notices. I got to issue 30-day notices, or this could be challenged and slow me down. And the reason this is helpful is because anytime there's anything that opens the door to slow your case down, it's going to cost you more, either in lost revenue or in attorney fees or whatever it is. It's always going to cost you more when you have to slow things down. So if you just get it right up front, and you provide the proper notices, you wait that additional 21 days, that might be an ounce of prevention that saves you a pound a cure later. So that's what all that means. Stay tuned for more videos and more updates as it relates to this new change effective April 2nd in the Michigan statutes. Again, if you're from Grand Rapids or other areas, this has already been something that has been on the books now for several years. But it is now statewide. So if you're not in a municipality and you're wondering, oh, does this apply to me? Yes, it does. And it does, effective April 2nd, 2025. I'll be happy to open up to any questions and answers. If you want to send me an email, please feel welcome to do so. Please look us up at stuartlawplc.com. It's been a pleasure to present to you today, and I look forward to answering any of your questions. Any questions from our webinar folks? Or virtual? All right.
Well, it looks like there's a little blue dot on the chat. Oh, that's just our audio. Oh,
Thank you for being here. Appreciate it.
yeah, no, that was helpful.
Absolutely.
Thank you.
Thank you, Kevin.